Hello, I'm Kevin Sutton of the Education Practice Group at Miller Johnson. We wanted to take a few minutes to share some thoughts with our clients about the recent Title IX regulations. As many of you know, on April 19th, the Department of Education issued final regulations implementing Title IX. The department spent months hearing from stakeholders through in-person meetings, town halls, and they received over 240,000 public comments. The regulations were expected in October of 23, then March of 24. Not surprisingly, they finally arrived during one of the busiest times of the year for schools. Of course, this marks the second set of significant revisions to the Title IX regulations in the past 5 years. Many of you will recall that back in 2020, in the midst of the COVID crisis, we received new regulations which took effect in August of that year. These new regulations match the 2020 version in terms of heft and significant changes. But I want to talk about a few key points right off the top. First, these new 2024 regulations are about 1,500 pages long. We are well aware of the fact that everyone is anxious to know how these new regulations will affect their policies and administrative guidelines, as well as the operational impacts that will flow from the new standards. This is the essence of the go slow to go fast situation. Now, there's a lot to digest, a lot to make sure we are cognizant of and are advising properly on. We are assessing the new regulations, reviewing the interpretive guidance that's been issued by the Department of Education, and we are constructing updated policies, guidelines, and training. Importantly, these new regulations do not take effect until August 1, 2024. And while there's been a lot in the news the last couple of days about a host of legal challenges that are being made to the new regulations, we do expect the effective date to stick. The good news about that is that it means we still have plenty of time to get ready for next school year and implement the needed changes. Our Miller Johnson school policy clients already know that we are going to be providing updates very, very soon, likely by Memorial Day. In terms of training, and many of you have already called to inquire, we will have comprehensive training on the new regulations ready to go in the next few weeks. Sessions are going to be offered in person as well as online. If you have interest in setting up training, please send me an email at suttonk@millerjohnson.com. That's the 30,000-foot view, but let's spend a few minutes talking about what sort of changes the Department of Ed gave us in these 1,500 pages. I want to stress that this is just a high-level overview. It's not intended to be a detailed list of all the changes contemplated in the new regulations, but we want to tell you some of the highlights. Generally, the regulations broaden the definition of discrimination based on sex to include not only discrimination based on sex stereotypes, sex characteristics, and pregnancy or related conditions, but also, for the first time, sexual orientation and gender identity. The term sex-based harassment also has been defined more broadly to include harassment based on sexual orientation and gender identity. Sex-based harassment creates a hostile environment in more situations than previously contemplated as well. A hostile environment exists when unwelcome sex-based conduct is subjectively and objectively offensive and is so severe or pervasive that it limits or denies a person's ability to participate in or benefit from the recipient's education program or activity. That's a legislative mouthful. And we will talk about in our training how that definition breaks down, how it differs from what we had before, and how it will impact practically going forward our inquiry into Title IX matters. A couple of other highlights under the new rules. The Department of Ed dramatically simplified the components of the grievance process each district must establish to address complaints of sex discrimination. This is good news for us. Generally, schools may go back to using the single investigator model, and schools may choose to use this model in some, but not all cases, as long as it's clear in their grievance procedures when it will use the single investigator model. And schools may offer an informal resolution process for sex discrimination complaints unless the complaint includes allegations that an employee engaged in sex-based harassment of a student, or unless such a process would conflict with federal, state, or local law. Those are two quick points that I think are really important. They will help, I think, simplify our processing of Title IX complaints, grievances, and our investigation process. So as you can see, very briefly, there's a lot to digest and a raft of important changes. Again, we will have training available soon. And for all of our Miller Johnson school policy clients, updates to policies and administrative regulations will be forthcoming in the weeks ahead. In the interim, if you have any questions, and we're sure there are many, please feel free to reach out to us. Again, via email, via phone. We'll try to give you the best answers we can early in this process. But again, a lot to digest. We're working on it, and we've got time. Again, these regulations do not take effect until August 1, 2024. So we won't eat up your entire summer, but it will be something to think about during the course of the summer. Thank you. We'll be in touch soon.